Welcome to NYPTI's Decisions on the Go, using AI for over a decade to help you listen to New York State Court of Appeals decisions on the go. After the podcast, visit www.nypti.com/law to read the full decision.
People v. Jahajwan Sabb, decided March 19, 2026. Rivera, J. The issue on appeal is whether Supreme Court erred when it sentenced defendant consecutively on 2 offenses after defendant pleaded guilty. We hold that it did. The prosecution failed to meet its burden of establishing that Supreme Court could lawfully sentence defendant consecutively because neither the allegations in the indictment on the count pleaded to nor defendant's admissions during his guilty plea allocutions showed that the 2 offenses were the result of separate and distinct acts as required by law. Thus, we affirm. 1. Defendant Jahajwan Sabb was indicted on 2 counts of murder in the second degree, 4 counts of attempted assault in the first degree, and 1 count of criminal possession of a weapon in the second degree. The charges arose from a drive-by shooting that defendant and 2 others participated in, which injured 4 men gathered on the street, including AT, and killed passerby SA, who was standing 10 feet away from the group, waiting to cross the street. In satisfaction of the indictment, defendant pleaded guilty to 1 count of manslaughter in the first degree as a lesser included offense to 1 of the murder counts for causing the death of SA, and to 1 count of attempted assault in the first degree with respect to AT. As agreed to by the parties, Supreme Court sentenced defendant consecutively to 25 years incarceration and 5 years post-release supervision, PRS, on the manslaughter count, and 10 years incarceration and 5 years PRS on the attempted assault count, for an aggregate term of 35 years incarceration. On appeal, defendant argued, as relevant here, that the consecutive sentences were unlawful. In a 3-2 decision, the Appellate Division modified Supreme Court's judgment to run the sentences concurrently, concluding that neither the allegations in the indictment nor defendant's admissions during his guilty plea allocutions established that the death and attempted assault arose from a separate and distinct pull of the firearms trigger by defendant. 2 justices dissented in part, concluding that the consecutive sentences were not illegal, relying primarily on assertions in defendant's pre-sentence report. One of the dissenting justices granted the prosecution leave to appeal. 2. The prosecution's argument before us is that the information contained in the record as a whole authorized Supreme Court to sentence defendant consecutively. In support of that claim, the prosecution urges us to adopt a new, more flexible and common-sense approach to evaluating the legality of consecutive sentences imposed upon conviction by guilty plea. Under this proposed rule, an appellate court may consider all information available to the trial court, which, as in this case, would include the pre-sentence report, grand jury minutes, and any pre-trial hearing testimony and exhibits. Defendant counters that there is no reason to deviate from our established precedent, which limits appellate review of consecutive sentences to the factual allegations in the indictment on the count pleaded to and a defendant's admissions during the plea allocutions. Defendant maintains that Supreme Court lacked authority to sentence him consecutively because the prosecution failed to satisfy its burden of establishing that the crimes to which defendant pleaded guilty were committed by separate and distinct acts, as required by law. As a threshold matter, contrary to the prosecution's assertions, defendant was not required to preserve his challenge to the legality of consecutive sentencing. We have recognized a narrow exception to the preservation rule where a court exceeds its powers and imposes a sentence that is illegal in a respect that is readily discernible from the trial record. Commonly referred to as the illegal sentence exception, this rule allows this court to review certain issues despite the absence of a timely objection at the trial court level. People v. Neves. This exception applies to a defendant's claim that the trial court unlawfully imposed consecutive sentences because the record does not demonstrate that the acts underlying the crimes are separate and distinct. See People v. Sams, confirming that a defendant's challenge to the legality of consecutive sentencing falls within the illegal sentence exception. That a defendant pleaded guilty in exchange for consecutive sentences is irrelevant because the illegal sentence exception is based on the court's lack of authority to impose a sentence impermissible under the law, regardless of the parties' agreement. Illegal sentence claim reviewable despite lack of preservation because it involves the essential nature of the right to be sentenced as provided by law. Indeed, in People v. Laureano, the court concluded that the trial court illegally imposed consecutive sentences, even though the defendant's conviction was pursuant to a negotiated plea agreement that required consecutive sentencing. The prosecution's preservation arguments are thus unavailing, and defendant's challenge to the legality of his consecutive sentences falls within our illegal sentence exception. We now turn to the merits and conclude that, based on the factual assertions in the count of the indictment pleaded to and the plea allocutions, Supreme Court lacked authority to sentence defendant consecutively. We further reject the prosecution's and the dissent's invitation to ignore our established precedent by expanding the sources of information that an appellate court may consider when assessing the legality of consecutive sentences where the defendant has pleaded guilty. 3. A. Penal Law 70.252 mandates concurrent sentences for 2 or more offenses committed through a single act or omission, or through an act or omission which in itself constituted one of the offenses and also was a material element of the other. The court has explained this binary requirement as prohibiting consecutive sentences where a single act constitutes 2 offenses or a single act constitutes one of the offenses and a material element of the other, Laureano. Where consecutive sentences are permissible, a trial court nonetheless retains discretion to impose concurrent sentences. See People v. McKnight, People v. Kusser. The prosecution has the burden of establishing the legality of consecutive sentences. People v. Rosas, citing Laureano, see also People v. Day. The defendant benefits if either prong of Penal Law 70.252 is present, and the prosecution's burden is to countermand both prongs. And it must satisfy its burden by identifying the facts which support its view. Laureano, see also People v. Ramirez. Imposition of consecutive sentences based on separate and distinct acts must be supported by identifiable facts. People v. Dean, a trial court may impose consecutive sentences when the facts demonstrate that the defendant's acts underlying the crimes are separate and distinct. An appellate court reviewing the legality of consecutive sentencing must first examine the statutory definitions of the crimes for which the defendant has been convicted and compare the actus reus elements of each to determine if they are, by definition, the same for both offenses, or if the actus reus for one offense is a material element of the second offense. See Laureano. If the statutory elements do overlap under either prong of Penal Law 70.252, the prosecution may yet establish the legality of consecutive sentencing by showing that the acts or omissions committed by the defendant were separate and distinct acts. Where the defendant has pleaded guilty to one or more counts alleged in the indictment, the prosecution may rely on the allegations of those counts as well as the facts adduced at the plea allocutions, and where the defendant has been convicted upon a plea to a lesser offense than that charged in the indictment, the prosecution may rely only on those facts and circumstances admitted during the plea allocutions, citing People v. Griffin. This rule is based on a trial court's limited authority to sentence a defendant only upon a factual finding of guilt by the trier of fact after trial or upon a defendant's admissions during a guilty plea allocution. With respect to the latter, as this court explained in People v. Griffin, when a defendant pleads guilty to any lesser crime than that charged in the indictment, that plea does not presuppose the truth of the facts pleaded in the indictment. Rather, the plea only admits the facts stated in the plea allocution as constituting the lesser crime. B. Defendant pleaded guilty to a reduced charge of first-degree manslaughter for causing the death of S.A. and to the first-degree attempted assault count charged in the indictment for the non-fatal injury of A.T., and the court imposed consecutive sentences. Under our established rule, we may consider the legality of the consecutive sentences based only on the facts defendant admitted at the plea allocution with respect to the manslaughter count and the facts asserted in the indictment and admitted at the plea allocution with respect to the first-degree assault count pertaining to A.T. See Laureano. See also Dean. Sentencing court was without authority to impose consecutive sentences where the defendant pleaded guilty to 3 counts of possessing a sexual performance by a child, but the prosecution did not include the date and time of each of the allegedly separate acts of downloading the digital images set forth in the indictment or include such facts in defendant's plea allocutions. The prosecution failed to meet its burden of establishing the legality of the consecutive sentences in this case because defendant did not admit any facts during his guilty plea allocutions, nor were there any allegations in the attempted assault count of the indictment pertaining to A.T. that support the prosecution's claim that he fired separate shots at each victim, causing separate injuries to each. Defendant's conviction for first-degree manslaughter required proof that he caused a person's death, see Penal Law 125.21, while his conviction for attempted first-degree assault only required proof that he attempted to cause serious physical injury to a person by means of a deadly weapon or dangerous instrument, see Penal Law 110.120.10. Defendant admitted during his plea allocution to the manslaughter offense that he caused the death of S.A. by shooting him with a firearm. Although the prosecution did not need to establish that defendant actually injured A.T. for the attempted assault count, the indictment alleged, and defendant admitted at the plea allocution, that he attempted to cause serious physical injury by shooting a firearm at A.T., causing an injury, emphasis added. In response to the court's inquiries, the prosecutor stated that the factual allocution on each separate plea was acceptable. As the statutory actus reus for each crime overlaps, because causing or attempting to cause serious physical injury or death by use of a firearm is required for each, the prosecution was required to establish that defendant's use of a firearm caused the injuries to S.A. and A.T. by separate and distinct acts, see Laureano. Given the court's questions and defendant's responses, the prosecution could have demonstrated the legality of consecutive sentencing by asking defendant to admit that he separately shot at the 2 victims, or that separate bullets from his firearm injured each victim. However, neither the plea allocutions nor the allegations supporting the attempted assault count of the indictment pertaining to A.T. contain a factual assertion that defendant separately shot at the 2 victims, or that each victim's injuries were caused by separate and distinct acts of defendant's use of the firearm. In other words, the prosecution failed to demonstrate that S.A.'s and A.T.'s respective injuries were not the result of defendant firing a single shot, see People v. Brathwaite, holding that consecutive sentencing was lawful because the trial record showed at least 9 shots were fired, and although the 2 deaths may be said to have occurred in the course of a single extended transaction, it was separate acts which caused each victim's death, given that there was no contention that it was the firing of the same shot that killed both victims. McKnight, allowing consecutive sentencing where separate shots were fired at both victims, but indicating concurrent sentencing would be mandated if the shots that hit one victim were the only shots fired at the other victim. See also People v. Battles, permitting consecutive sentences for crimes committed against 3 victims whom defendants separately doused with gasoline, but requiring concurrent sentencing with respect to a 4th victim sprayed with gasoline as a result of the dousing of others. Contrary to the dissent's assertions, the prosecutor should have been aware at the time of the plea, based on our unambiguous case law, that they had the burden of ensuring defendant allocated to sufficient facts to establish that he separately shot at the two victims or that the victims were injured by separate bullets in order for consecutive sentencing to be legally authorized. But because the prosecutor failed to satisfy their burden and place on the record the alleged separate and distinct acts underlying the two crimes, see Laureano, the trial court had no legal authority to impose consecutive sentences in this case. 4. The prosecution argues, and the dissent takes up the charge, that we should adopt a different rule that would allow an appellate court evaluating the legality of consecutive sentences to consider all information available to the trial court. That expansion of the sources the prosecution can rely on to meet its burden, which the prosecution characterizes as a more flexible approach, would require overruling decades of well-established precedent, and neither the prosecution nor the dissent provides any basis for upending our jurisprudence in such a fashion. See also Laureano, Dean. Indeed, the dissent elides that its approach would require us to expand or amend our existing case law. To the extent that the prosecution and the dissent claim the current rule unfairly curtails a sentencing court's discretion to impose consecutive sentences where the defendant accepts a mutually beneficial plea bargain, the Laureano majority implicitly rejected this same argument as raised by the dissent. We decline this invitation to deviate from our precedent. Our existing rule is long-standing, straightforward, well understood, and lower courts have applied it consistently. See e.g. People v. Party, People v. Penna, People v. Robinson, People v. Quirk, People v. Wright. The dissent invokes the finality of plea agreements and the importance of pre-sentence reports, all the while disregarding our substantial body of case law, making clear that the prosecution bears the burden of proving the legality of consecutive sentencing based on the indictment and plea allocution. This rule recognizes that when a defendant pleads guilty, they must admit to the facts necessary for a sentence to be legal, meaning a sentence that comports with the law and falls within the statutory range for the crime of conviction. Thus, when a court assesses the legality of consecutive sentencing upon a guilty plea, the court cannot go beyond the defendant's admissions and consider information used to impose a sentence that is appropriate within those legal limits. The dissent's post-plea material of choice, the pre-sentence report, is an especially problematic document by which to determine the legality of a sentence, as the report may contain unverified hearsay. Furthermore, despite the dissent's and the prosecution's contentions, our rule does not impose an undue burden on the prosecution to establish the legality of consecutive sentencing in cases where a defendant pleads guilty. Prosecutors regularly draft indictments, and they may request further inquiry of a defendant before the court accepts a plea to ensure the adequacy of the allocution and record. Defendant's case illustrates the point. In response to the court's inquiry as to whether the allocutions were acceptable, the prosecutor needed only request that defendant admit he separately shot at the two victims, or that their distinct injuries were caused by separate shots from his firearm. Thus, under our existing rule, the prosecution could easily have established the legality of consecutive sentencing with a question or two, and there can be no excuse for their failure to do so. In sum, the trial court could not lawfully impose consecutive sentences in this case. The prosecution did not request before the appellate division, nor before us, that the matter be remitted for it to withdraw its consent to the pleas, and therefore, as the appellate division ordered below, defendant sentences must be run concurrently. Accordingly, the appellate division order insofar as appealed from should be affirmed. Order insofar as appealed from affirmed. Opinion by Judge Rivera. Opinion by Judge Rivera. Chief Judge Wilson and Judges Canataro, Troutman, and Holligan concur. Judge Singas dissents in an opinion in which Judge Garcia concurs. Decided March 19, 2026.
Welcome to NYPTI's Decisions on the Go, using AI for over a decade to help you listen to New York State Court of Appeals decisions on the go. After the podcast, visit www.nypti.com/law to read the full decision.